right, hello and welcome to today's Verdict, the interactive show that gives you your legal rights and options. I'm your host and trial attorney, David Lesh. Well, today's Verdict is always encouraging you to stay connected. Make sure to tweet me at David Lesh and hashtag Ask Today's Verdict if you have a question. And check us out at bronxnet.tv. Uninsured motorists and some coverages are mandatory in the state of New York, but what is it? What does it imply? And what does no liability insurance mean? Here to tell us more about it is attorney William Cooper, who I basically know as Billy. And welcome back.
Thank you.
It's nice to have you as a returning guest, and we're going to be talking about automobiles. Let's maybe start with the basics. Is it mandatory to have insurance if you're driving a vehicle in the city of New York? 100%.
Any driver in New York State in general has to have insurance when they drive their vehicle. The minimum that you have is what's called a 25/50 policy, which means you have $25,000 in coverage that protects you, and an additional 50, a total of 50 if more than one person is injured. But what we're going to talk about and where it gets confusing is if you are protected when you have insurance, or if you're really protecting the other person who's involved, the other vehicle, if you're at fault.
All right, so let's get down to it. Let's say a vehicle ends up hitting a pedestrian as the pedestrian is crossing the street. And this particular vehicle, well, I guess the first thing you would want to find out is whether the vehicle has any insurance, correct?
Certainly.
So what's the first thing you do? You contact their insurance company, or how do you recognize whether there is insurance?
So in New York State, when there is a police report, and more often than not there is in a scenario like that, on the police report there's an indication of who the insurance company is. What an attorney will do for you is contact that insurance company and immediately find out what the coverage is for the vehicle. In other words, is there a minimum $25,000 policy, or is there a greater amount? Is there $100,000 or even $500,000 in coverage? Because whatever the limit is, that's the maximum that you as the injured person can receive.
And this money would go towards your injuries if you have injuries as a result of the automobile accident.
Correct.
So it could be you could try and get $25,000, you can try and get $100,000, $300,000, $500,000. It depends on what that coverage is. And you don't know what it is until you actually reach out to the insurance company.
Exactly. Once you speak with the insurance company, they legally have to inform you in terms of what the coverage is. Again, the challenge can be that you are limited, even if, say, you have very serious injuries. If you have a broken leg, you need surgery, you're hospitalized, you're out of work for months. If there's a $25,000 policy, that's the most you can get. If there's a $500,000 policy, that's the most you can get for the same injury. That's why it's so important to know what the insurance coverage is.
All right, so now let's talk about ways to protect yourself. If you're going to be, or hopefully you're not, but if you end up involved in an accident with a vehicle that does not have enough insurance to compensate you, or doesn't have any insurance, what could you do to protect yourself?
I'm glad you asked that. The most important thing that I discuss with friends, family, and clients is the following. Everyone thinks that if they have insurance, that the amount of coverage that they have will protect them and their family or people in their vehicle. That is not true. The amount of coverage that you have actually protects others. But there's something called UM or SUM coverage, which means uninsured or supplementary uninsured motorist coverage, which actually protects you as the person in your vehicle or passengers in your vehicle.
So if you're injured, and even though your car wasn't involved in the accident, your car has been sitting in your driveway the entire time, but you have this additional coverage, there's a way you could still recover off of your car's own insurance company.
Exactly right. So what happens first is that you have to deal, and your attorney, if you have one, will deal directly with the other vehicle's insurance first. Let's take an example. Let's say, for the sake of discussion, that you were injured with very severe injuries that are worth $150,000. And the other vehicle that strikes you has a minimum $25,000 policy. Once you get that $25,000, if you have SUM coverage, supplementary coverage, which is greater than, more than that $25,000 that the other vehicle has, you can supplement or get additional money from your own insurance to pay you for those injuries.
And how much can you get? Let's say you have $100,000 underinsured or supplemental uninsured motorist coverage yourself, and this vehicle that hits you only has a $25,000 policy. What can you go for?
So the most you can get is the full amount of your own SUM supplementary coverage. So in your example, if the other vehicle is $25,000 and you have $100,000, the total you can get is $100,000.
So you can get $75,000 from your own coverage.
Correct. You can't stack those
You can't
policies.
stack it up.
Right.
Do people know about this particular form of insurance that you can have?
Unfortunately, people don't know about it, and even more unfortunately is the insurance companies are not required to tell you when you get your insurance about SUM coverage. In 2018, things changed for the better in that in New York, if you have up to $250,000 in coverage, you have to be provided with that matching SUM coverage. So whatever you have for someone else, you have that own SUM coverage yourself. It's so minimal, by the way, to get additional.
In terms of how much it costs?
So many. It's a few extra dollars a month.
Is that why the insurance brokers don't tell you about it, or are they just afraid that they're going to be exposed with respect to this type of liability? Why you'd think they'd want to let you know as your insurance broker that you can get this type of insurance?
You would think so. The challenge is that realistically, the insurance companies save millions and billions of dollars per year
by not offering it.
By not offering it. Because if it's not there and it's not available and someone has a horrendous injury, they don't have to pay.
Let me ask you a question. Somebody who's watching right now, they're about to own a vehicle. They're either going to be leasing it or buying it outright, and they're going to be looking to get some type of insurance coverage because they have to, because that's the law. What would you recommend to them, to somebody who's walking into an insurance broker's or on the phone with a Geico or a State Farm and getting insurance for their vehicle? What would you recommend?
So the first thing that I would recommend is ask the insurance broker, ask the insurance company, what is the maximum amount that is available that you can afford to pay, and what is the cost to get that matching SUM-UM coverage? Because that way, not only are you and your family protected if someone does something wrong and you go through a red light yourself, but you are protected if someone strikes your vehicle. So you want to ask, what is the maximum SUM that I can get, and how much will it cost? And you'll be pleasantly surprised. It will be very affordable.
Just wondering the ballpark of how much extra on an insurance policy would that be? Another $100 a month, or?
So it's even less than that. I actually spoke to someone yesterday from State Farm, just by coincidence. I was curious. I said, what is the extra cost per month? And it's usually dollars. It can be $10s or $20 per month extra to get the SUM coverage to match what you have. Again, depending upon the level that you go to, but it's very reasonable.
All right, Billy. Let's talk about real property. Real property is what?
Real property can be a home. It can be a building. It can be a department store. It can be a supermarket. So any place where a person goes, you can go to shop. You can be at your house. You can go to visit someone. That can be considered real property. And then we have issues, of course, as you know, where people unfortunately get injured in those locations.
All right. And yet, when we were talking about automobiles, where it's mandatory to have insurance, it's not mandatory for a landlord or for a building owner to have insurance. Am I correct?
That is correct. And it makes it very challenging because oftentimes we'll see clients, people who were injured at a location, and will come to learn that the store, for example, did not have any insurance, or the building did not have any. And in those situations, it's most challenging because you can try and get a recovery from the owner or the proprietor, but it's much more difficult.
So let's get inside an apartment, or at least an apartment building. What types of injuries sometimes come through your office in terms of injuries that are a result of an accident in an apartment building?
So the most typical in an apartment building would be someone trips and fall, they slip and fall, or they have a ceiling might fall on their head, or we have situations in the Bronx and in Brooklyn quite often where there are improper handrails. There's no railings placed on walk-ups, things of that nature. So you'll have a situation where someone is going to a building, it's in the evening, it's not properly lit, and they go to leave and they end up tumbling or falling off because there's no handrail, or someone is mopping in the basement of an apartment building. They fail to put up proper signage to notify people, and they end up slipping and becoming quite injured.
You know, I understand that part of proving your case with respect to these premises liability cases is showing that the landlord or the owner knew or should have known that this particular defect that caused your injury, whether it's water on the floor or broken ceiling, that they knew about it, that they should have known about it. How do you let them know about it before it happens?
Excellent question. Always interesting, because most clients, most people who are injured presume if I'm hurt somewhere, I automatically am entitled to money. And that's not true. We have to prove that the owners had notice, that they were aware of this dangerous condition, either what's called actual notice, where they may have seen it themselves or created the condition, or something called constructive notice, which basically means the defect or dangerous condition was there long enough that they should have seen and corrected it. If we can't prove that the owner knew or should have known about the danger, then they are not responsible.
So how do you protect yourself as a tenant if there are potential dangers that may result in an injury down the road? Like what do you do?
So it sounds challenging at times, but we encourage people, notify. In other words, whether it's a phone call, which isn't quite as good as texting or emailing or putting something in writing, once something is documented that there is a dangerous condition, and then unfortunately if someone gets injured, we can go back and say, look, they were notified about it last month, 3 months ago, 6 months ago, never did anything to correct it. That's much more beneficial.
I know there's also 311. You make a complaint to the city of New York that letting the city know that your landlord hasn't fixed the ceiling or hasn't fixed the plumbing or something like that. Does that constitute a notice with respect to a landlord or an owner?
So it's an interesting question, because there's two different answers. If it's a privately owned building and it's maintained that way, then it can be sufficient. If it's a municipally owned building, in other words, if it's owned by the city of New York or by a county or a town, then it's a little bit different, because all of the municipalities have something that's called the prior written notice requirement, in which they have to actually be told in writing about defective or dangerous conditions. So 311 is a good way to go. It's not always, at least in my experience, something that locks in the notice requirement.
And by the way, we're also discussing accidents or issues that occur. You see in department stores, that could be in a grocery aisle where somebody slips and falls on grapes that have been left out. But you have to make sure that those grapes were on the floor for enough time that they should have been mopped up or swept up. Not just, if somebody drops a couple of grapes right before you walk and slip on them, well, the store's not going to be responsible for that. They can't monitor every grape that falls on the floor.
Exactly, and it's logical, right? It makes sense. If you are an owner and someone is walking in and it's grapes or their ice cream and something falls, and then 5 seconds later I happen to walk by and slip and are injured, there's no way that the owner could have prevented that. On the other hand, if they have cameras and that spill, those grapes, that ice cream, have been down there for 15, 20 minutes, or I reported it to someone and they said, we'll get to it later, now that can fall into the category of notice, constructive notice. They should have taken care of it.
Well, let me ask you a question. We were here earlier discussing ways to protect yourself with respect to automobiles. And accidents where you might be involved in an accident with an automobile that either doesn't have insurance or has a minimum amount of insurance. Can you protect yourself with respect to injuries that can occur in a premises liability case?
The protection that you can have falls more along the lines of having adequate health insurance for yourself. We have not found that there's homeowners insurance, for example, or renters insurance, which carries over and covers you if you are injured in a department store on someone else's premises. So that SUM, that uninsured motorist protection that we talked about.
You don't have that with the premises.
Nothing like that with the premises.
So really, what do you do? I mean, you're involved in an accident with a property owner. Just cross your fingers that there's insurance. What's the first thing that you do is when they come into you and they see you?
Well, the first thing that we do is we find out, first of all, who is the actual owner. Through land records, we find out who the owner of the premises is. We notify them. We check to find if there is any insurance coverage. Usually there is for buildings. Usually there is for businesses that have been established for some period of time. And then once we establish that, we reach out and we have contact with the insurance company. But the truth is, sometimes there's not insurance.
Do you continue with the case if there's not insurance, or is it a case-by-case basis?
It's really case-by-case. So our goal when we represent people is to get them a fair recovery. Our goal is not to bankrupt businesses, but if a business is successful and prosperous and just chooses not to have insurance to save a few dollars, we'll do everything we can for the client. But if it's a mom and pop scenario and they happen to not have any assets,
Right.
then we have to have that discussion.
All right. Well, listen, we don't have really any more time, but we expect you to come back and give us a topic. And we'd love when you come here. We really do.
Thank you. It's my pleasure. Thank you.
All right. Well, thank you so much for the information, William. We have to take a short break, but we will be back right after this.